What are venue and jurisdiction in Texas family law cases? And where can I file my family law case? If you're filing a family law case, whether it is a divorce or a suit affecting parent-child relationship in the state of Texas, there are two things you need to consider when deciding where to file. The first is venue. Venue is the idea of which county you can file your case in. In the case of a divorce, venue is going to be the county in which either party resides. So for example, if you are getting divorced in Texas and you live in Tarrant County and your spouse lives in Denton County, venue is technically proper in either Tarrant or Denton counties. Now, of course, if you live in Tarrant County, it's going to be in your best interest to file in the county in which you live because it's far more convenient. And of course, for your spouse, if they live in a different county, they will want to file in the county in which they live. If there are two competing filings and one of you files in Tarrant County and the other one of you files in Denton County, then typically the first to file controls. However, there are certain situations in which perhaps you filed simultaneously and one of you was able to execute service on the other one first. In that case, the first to perfect service, the first to serve the other party, then controls. So venue would be proper in the county in which the first filing and the first person who was able to serve the other party occurred. You can certainly request a motion to transfer venue for inconvenient forum. However, in a case where both of you have resided in your county for the requisite amount of time, venue is technically going to be proper in either county, and it is highly unlikely that a court would transfer venue in that case. There are, of course, certain situations where, for example, if there is real property in the state and it is in the county in which you reside, and your spouse happens to reside in another county and filed in another county, then it's possible that the court might consider transferring venue to where the real property is. However, it is more likely that the first person to file, the first person to perfect service, is going to control as far as venue goes. Now, that was the divorce. What if we're just talking about a suit affecting parent-child relationship? So there's no divorce, there's no property, and we're just talking about kids and kid issues. Venue is technically proper in the county in which the child resides, assuming that the child resides in Texas. So, once we have venue squared away, the question is, does this court in this county actually have jurisdiction over this case? And jurisdiction, it's complicated even for seasoned attorneys. Jurisdiction breaks down to two components. We have subject matter jurisdiction, which is whether the court has jurisdiction over the themes of the issues involved in your case. So in a divorce case, subject matter jurisdiction is conveyed when one party has lived in the state of Texas for 6 months and in the county in question for 90 days. So if you are contemplating filing for divorce, you have to have lived in Texas for 6 months, and whichever county you choose to file in, you have to have resided in that county for 90 days. In a case involving children, subject matter jurisdiction over a child is going to be conveyed when that child has lived in Texas for 6 months, thus giving Texas courts jurisdiction over that child. Again, venue is going to be proper in the county in which the child resides. However, Texas, the state of Texas, any court in Texas could theoretically exercise jurisdiction over the child. So that is subject matter jurisdiction. The next component of jurisdiction is personal jurisdiction. Personal jurisdiction is the question of whether a particular court in a particular state can adjudicate issues that involve you as an individual. So if you are a Texas resident, Texas automatically has jurisdiction over you by virtue of the fact that you live in Texas and you avail yourself of the state's benefits, roads, businesses, you transact within the state of Texas, and therefore you are subject to jurisdiction in the state of Texas. You can be sued by anyone at any time just by virtue of the fact that you live here, you maintain property here. Even if you just lease a business here, your principal place of residence is Texas. So what happens if you are trying to file for divorce or trying to file a suit affecting parent-child relationship and your spouse or the other parent of your child does not reside in Texas? This is where things get a little tricky. So in order to exercise personal jurisdiction over a non-resident of the state of Texas. There are a number of ways to do so. The first is if you are filing for divorce and your spouse has left the state of Texas, you can still establish personal jurisdiction over your spouse if the state of Texas was the last state in which you cohabitated as spouses, and you are filing for divorce within 2 years of when your spouse left the state. There are also certain things called long-arm statutes, and the Texas Constitution allows us certain mechanisms to exercise jurisdiction over non-resident parties. But those are very difficult to prove and to avail ourselves of in cases where the respondent is an individual who does not reside here, who perhaps has not resided here. Now, if we're talking about a suit affecting parent-child relationship and you and your child have been here for 6 months and you file in the county in which you reside, but the child's other parent does not reside in Texas, there are 7 ways that you can exercise personal jurisdiction over a non-resident parent. The first is personal service. If you are able to personally serve the non-resident parent in the state of Texas, then Texas has automatically acquired jurisdiction over that person by virtue of the fact that they were served in the state in which you are trying to sue them. So that means that if your non-resident parent comes to Texas for visitation, or you exchange the child for visitations in the state of Texas, even if it's just at the airport, Texas therefore has acquired personal jurisdiction over that parent. The second way is if that parent consents to jurisdiction in Texas. So let's say, for example, you file a suit affecting parent-child relationship in Tarrant County, you have a citation issued, and your non-resident parent lives in Louisiana. You call up the local constable in Louisiana and you're able to serve him or her in the state of Louisiana where they reside. If they file into the case, if they file an answer or any type of affirmative pleading, if they voluntarily submit themselves to the jurisdiction of the court and say, yes, I am willing to have this case here, then they are automatically subject to personal jurisdiction in the state of Texas. There is an exception to this. If you serve a non-resident parent out of state and they believe that Texas should not have jurisdiction, they can file a document that is called a special appearance and plea to the jurisdiction, in which they essentially file a limited appearance. So they say, yes, I am filing an appearance in this case only for the purpose of contesting jurisdiction. I don't live in Texas. I have never been to Texas. Texas has no jurisdiction over me in any way in this suit affecting parent-child relationship. And therefore, I think that the case needs to be dismissed and the case needs to be brought in my home state where I am subject to personal jurisdiction. The third way to exercise personal jurisdiction over a non-resident parent is if that parent at any time resided with the child in Texas. There is no time limit. They could have only been here for a week and then said, you know what, forget it, I'm going back to Alabama. But if they ever resided in Texas and they moved here with the intent to remain, even if they didn't remain, they can still be subject to personal jurisdiction in courts in Texas. The fourth way to exercise personal jurisdiction over a non-resident parent is if that parent resided in Texas prior to the child being born and provided any sort of prenatal support financially to the parent who had the child. So in this case, you would assume a mother and a father, and if the father lives out of state, but at any point lived with the mother in state and helped pay for OBGYN bills or any sort of prenatal care, then that person can be subject to personal jurisdiction in the state of Texas. The fifth is if the child resides in Texas due to the acts of a non-resident. So if the child is living in Texas due to the directive, if the non-resident parent said, you have to move to Texas and live with an aunt or my mother or someone that I need to take care of you, then the non-resident parent can be subject to personal jurisdiction in Texas. The sixth way is if the non-resident parent had sexual intercourse in the state of Texas that likely resulted in the conception of the child. This one's kind of self-explanatory. And the seventh is if the non-resident parent registered with the Texas Paternity Registry, acknowledging paternity of a child that is born in Texas, even if that parent does not reside here. If you satisfy any one of these 7 ways to exercise personal jurisdiction over a non-resident parent, then you can properly proceed with a suit in the state of Texas. What happens if you can't? What happens if you have a non-resident parent or a non-resident spouse and you don't satisfy any of these criteria. In that case, chances are Texas is not going to be the appropriate place for you to file either your divorce or your suit affecting parent-child relationship. But as I mentioned earlier, jurisdiction issues are incredibly difficult. And if you have any questions whatsoever, or you need any assistance deciding whether or not Texas is the proper place for you to be filing your case, then absolutely reach out to the family law attorneys at Varghese Summersett. The family law attorneys here at Varghese Summersett are incredibly knowledgeable at how to navigate those waters. Thank you so much for watching. If you have any questions or comments, leave them down below. Otherwise, you can find us at versustexas.com.